answer. And I understand that the record should reflect that just before the hearing, you advised me that you had just received some documents from Mr. Apuzzo, and you had not reviewed them, correct? And the record reflected I did offer you the opportunity, if you sought it, to take a short time to review those documents before we proceeded with the hearing, and you indicated that you would prefer to proceed.
Yes, I believe it's not necessary because the documents are not relevant to the case of file.
All right, well, I'll hear to the extent that there are going to be evidential objections, I'll hear those as we proceed. Mr. Apuzzo, you're the objector in this matter. What do you wish to offer? Wish to make an opening statement?
Yes, Your Honor, the opening statement, under Article 2, Section 1, Clause 5, the President-elect at some point has to prove that he's a natural-born citizen. And that's defined by case law going back to the founding. It's a child born in the country to citizen parents. That always has been the definition of a natural-born citizen. We've had a question as to what a citizen is, and that was resolved by the 14th Amendment. The case that gave us directly a definition of it is Minor versus Hackersack. There were earlier cases, but for the sake of brevity, I'm just going to mention that case, and I did cite them in the objection.
Yes.
And Minor defined a natural-born citizen as a child born in a country to citizen parents. It did not go ahead and define what a citizen is under the 14th Amendment, because it was not necessary, because Virginia Minor had citizen parents. And there have been doubts, the court said there have been doubts as to whether a child born in the country to alien parents is a citizen.
Now, this position you're advocating, but I should note, I think it's fair to say, Mr. Apuzzo, that you have two basic positions here. One, I gather, is, and I don't want to, just so that we set the framework for what you're talking now, is one is that Mr. Obama was not born in the United States. That's position one, correct?
Well, and he hasn't proven that
Right.
he
Hasn't proven.
Yes.
And number two is that even if he was, you have this argument with regard to the natural-born citizen, correct?
That's correct.
Because that's the context of the second of what you're discussing right now, the natural-born citizen.
Yes.
Correct? All right.
Yeah. With respect to, well, let's call it the citizen parents, that can be decided as a matter of law, because
The facts are not in dispute
Yes.
with regard to the fact that his father was, that you would concede yourself, that the president's father was not born in the United States. That's not an issue.
Okay, now, it's not a matter of that he was not born in the United States. That's not what we're arguing, Your Honor. There's confusion sometimes with that. We're saying that he's not a citizen. He could be a naturalized citizen.
And that would also not be in dispute, would it not? No.
Yeah, so he was never a U.S. citizen, never naturalized, never intended to be one. He was not an immigrant. He was here on a visa, student visa. So that's just, as a matter of law, the court can decide that, whether or not he's a natural-born citizen. And the definition was confirmed in U.S. versus Mark, U.S. Supreme Court, 1898. Basically confirmed the minor definition, confirmed it, distinguished between a citizen and a natural-born citizen, found that Wong was born in the United States to domiciled alien parents, and said that was sufficient to make him a citizen of the United States under the 14th Amendment. The 14th Amendment has nothing to do with the natural-born citizen clause, Article 2. There's nothing in the text or in the debates which indicates that Congress amended Article 2. There's no talk about natural-born citizen. It was basically citizen. Again, the definition of the TEL really starts out in the Law of Nations. It's a treatise, the Law of Nations, which comes from natural law, and he codifies the Law of Nations. And there's a lot of evidence, historical evidence, that the founding fathers heavily relied upon the TEL and the Law of Nations in founding the nation and bringing the nation forward in the early period. They never looked to the English common law on a national level. The English common law was accepted in the states. They had detention statutes. They had even constitutional provisions in the constitutions of the states saying that the English common law would prevail until amended by state legislature. Nothing of this sort on the national level. There's nothing in the U.S. Constitution which says the English common law shall prevail. On the contrary, Your Honor, it says the Law of Nations is actually written in the U.S. Constitution. And there's case law, there's historical references that the law of nations actually became adopted by the United States on a national level, became actual common law. And that is why Minor says that the common law defines a natural born citizen. So, to move on, Your Honor, I know this is just the opening argument. And so, then move on.
Excuse me. No. No cameras except the fixed tripod camera.
Sorry, I didn't hear that.
That's okay.
So just to move forward, Your Honor, the law of nations is a definition which became American common law. Minor says under the common law. Now, that cannot be the English common law because the English common law has no reference to the citizenship of the parents. So it was American common law. Law of nations, born in the country of citizen parents, Mr. Obama does not meet that definition because of not having parents, which is conceded, and also because there's no evidence provided to the state of New Jersey that he, in fact, was born in the United States. We have an internet image that's on the White House server. That's all. That's all we have. And everybody just assumes that he's presented this document. Now, he might have a valid birth certificate in Hawaii. We don't know that. And we, of course, we surely wouldn't deny, him a right to say, look, here's my birth certificate. But this is, running for office. If I want to go to get a driver's license, I have to have 6 points. And I just went like a couple months ago, and I've been driving in New Jersey since I was like 17. I've lived here for virtually all my life, and I had to go through the process all over again. Where's this and where's that, and pulling stuff out of my wallet, credit cards and things. So it's a process that, and we're talking about the President of the United States, tremendous power, the nuclear button, so to speak, the nuclear football. We have to have at least a minimum process. The Secretary of State has to protect the integrity of the election. So we're saying that Mr. Obama, until he provides the evidence that he was born here with a valid, competent, sufficient evidence, then we cannot assume that he was. And again, he would be disqualified under the definition of a natural born citizen. We also have testimony, we're going to hear from an expert witness as to that we cannot rely on that computer image. I also have some affidavits and some other reports here from other witnesses who could not be here personally because of the time frame and the distance. But I do have one witness here, Mr. Wilcox, who will testify as to his report, and I have it for Your Honor. Thank you.
Yes. I'd like us to call back to the point of why we are here today, which is the presidential primary ballot. In New Jersey, objections must be based on the statutory requirements for a presidential petition under NJSA 19 and specify in detail each individual defect. The challenge can only be based upon the criteria for a presidential primary petition under New Jersey law. The qualifications for a presidential primary candidate in New Jersey are as follows. Must be signed by at least 1,000 voters throughout the entire state. Candidate's name and address must appear on each petition. The circulator witness is the person who collected the signatures on the petition and must complete and sign the affidavit where indicated. Circulator must sign the petition as petitioner on a numbered line, and location of signature must be identified.
Just for the record, NJSA.
NJSA 1925-3, 1923-7, 1923-11. Even if petitioners did have an authentic copy of Obama's birth certificate, there is no requirement under New Jersey law that the candidate for president publish, produce, or release an official birth certificate. The claim is not relevant to the presidential primary ballot. In fact, under New Jersey law 1925-3, it is not required to have the consent of the person who is running for the presidential primary endorse the petition.
So somebody could be running around with a petition to put you on the ballot, and we've got 1,000 signatures, and if you met everything else on there, you'd be on the ballot whether you wanted to be or not.
Yep.
Is what you're saying.
100%. And it is the petitioner's burden of proof, not mine, to present evidence that is authentic and authenticated as in the rules of evidence that presents their opinion that that the petition does not meet statutory requirements when it does.
So, do I understand your position to be, clarify what your position is? Are you suggesting that the objection that Mr. Apuzzo was talking about the birth certificate or lack of proof, is not a cognizable issue under the statute with regard to the challenge?
It is not. And even if he were to raise that issue, every federal, state, and administrative court that has been before this issue has ruled that he is in fact eligible to be president.
All right. Mr. Apuzzo, since the council raises what sounds like a fundamental challenge to the theory upon which you're presenting here, in terms of whether those are legitimate issues to raise in this context, in this proceeding, what do you have to say about that? I mean, is the challenge that you're raising one that meets the requirements of the statutory provisions as to what is required to put somebody on the ballot?
Yes, Your Honor.
For the primary?
According, Your Honor, 19:23-7, okay, says that the circulator has to say that the candidate is qualified. The circulator. It also says that the person endorsed has to say that he's qualified.
Where does it say that? Does it say
In
that?
19:23-7.
What does it say?
It says, the petition shall further state the residence and post office address of each person so endorsed, and shall certify that the person or persons so endorsed is or are legally qualified under the laws of this state to be nominated, and is or are a member or members of the political party named in the petition.
So who's that requirement placed on? Is it placed on the person who's the nominee, the person being nominated by the petition, or is it on the circulator?
On the circulator.
On the circulator.
Yes, number one. On the
So your
circulator.
challenge then, is your challenge then to the circulators having said that Obama was qualified?
Yes, that's not here that I'm aware of. I have number two argument. That's number one.
Right.
The circulator, okay, which there's no evidence that the circulator has said that on these petitions, number one. Number two, the same statute says, accompanying the petition, each person endorsed therein, now that's Mr. Obama, shall file a certificate stating that he is qualified for the office mentioned in the petition, and he is a member of a political party named therein, that he consents to stand as a candidate for nomination at the ensuing primary election of such political party, and that if nominated, he consents to accept the nomination, and it goes on. Now, we don't need the consent, which as stated, statute says you don't need consent. Doesn't say you don't need to state you're qualified. Consent is one thing, but the certification that you're qualified is a completely other element, which is not covered by statute in terms of exempting that particular requirement.
Your Honor, I'd like to object. Objectors did not challenge the petition themselves, they challenged Obama's eligibility. And the statute that counsel is reading from actually refers to the delegates, not the candidate for the presidential primary. Remember, the primary election is to elect the delegates. So 19.
You're not voting directly
No.
voting for
No.
Mr. Obama.
No, you're not. And because the candidate refers to the delegates, not the candidate for presidency, we're endorsing the delegates in that statutory provision he's reading from.
Your Honor, where does the petition say that there's a delegate being, delegates, that's a different process. You elect the electors and.
The delegate process is the primary.
Isn't it the fact that, and you've heard this, throughout the country, where they talk about, whether it's a winner-take-all primary or it's a proportional primary, that when the voters vote, either somebody gets all the delegates or they get some of the delegates, or, it's split up depending on how the individual state works. Aren't we really voting, for delegates who may or may not be pledged to the person who wins the primary?
Well, at some point, not at this stage.
No, that is the purpose of the primary.
All right, okay, all right. Your objection is noted. All right.
And Your Honor, and also, so qualified, and then the Secretary of State in the instructions clearly says you have to be a natural born citizen. There's,
Well, I don't think there's any dispute, regardless of what the definition is, what it actually means. There's no dispute what the constitutional provision says in so many words. It says natural born citizen, that's not a dispute. The question may be, what does that mean? But there's not a question of what it actually says. I mean, it says natural born citizen. So that's not, that
Yeah.
portion of it certainly is not in dispute.
Your Honor, if I may, just to reinforce what I just said, the statute again basically repeats the same thing in a different context. The context that I wrote was about the content of the petition. Then, if Your Honor reads 19:23-15, it says the same thing again. It says the circulator has to qualify, and excuse me, that's the what is that? The exceptions. What I just said was 19:23-15 is that there's got to be a certificate of let's see, accompanying the petition attached thereto, each person endorsed therein shall file a certificate. That's 19:23-15. 19:23-15. Each person endorsed therein. Okay, there's no delegate endorsed in these petitions. There's no names. There's no delegate or elector. Mr. Obama's endorsed. Okay, clearly, I mean, we're not talking about electors here. So he's got to file a certificate. And also, 19:23-16 says the person nominated has to file a certificate. So, each person endorsed.
So the question is, who's being nominated, who's being endorsed, correct?
Yes, clearly the statutes require that the person nominated or endorsed has to file a certificate saying they're qualified. Qualified means under the Constitution. And finally, Your Honor, on this point, if we go to the election contest aspect, that would be 19:29-1, which is grounds for election contest, which would follow this particular phase.
Well, we're not contesting the election.
No.
Isn't that premature?
Yeah, but just so that, Your Honor,
Maybe
yes.
it is.
Yeah, but but it's relevant because when you challenge an election, one of the grounds of challenging an election, when the incumbent was not eligible to the office at the time of the election.
Well, it may say that, but we're certainly not at that stage yet.
Yeah, but we have to understand.
Fortunately or unfortunately, we've got 6 months or 7 months of a campaign yet before we get to that point.
Yeah, but
And we certainly haven't had the primary election yet, so I
But-
think that's premature.
it's telling us that New Jersey requires that you have to be eligible. It's just, it's there, it's in the state statutes.
Okay. NJSA 19:23-15 applies to the delegates, because you elected delegates, and the delegates must certify that they are your representative from your county. You know, they reside in the county, they're of age, they're registered for the party that they're being endorsed to then go as a delegate and vote for the president at the electoral college.
All right, so.
Additionally,
I'm sorry, go ahead.
additionally, 1929-1B, when an incumbent was not eligible for the office at the time of the election, which is the objection to the election, the contest, it's not relevant since Obama will not be elected during the primary.
Okay. That objection is noted, and we'll deal with that objection.